Hello everyone, welcome back to our channel Law Point. This is your host Reenu Thomas. Our previous episodes were on the topic arrest. So today in this episode we will cover all the frequently asked questions on this topic. For this we have our Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to answer all our queries. So here goes our first question. If an Indian goes to a foreign country, commits a crime there and returns back to India, then is the Indian police empowered or authorized to arrest such a person?
An Indian citizen is held liable for prosecution in India for the act committed in foreign land if that act committed is an offence recognized in India. For example, if a husband abuses his wife in a foreign land, the wife can file a case in India as against this abuse. Then, though the husband has committed the abuse in a foreign land, he can still be tried by a court of law in India. Now, if a victim of theft in Abu Dhabi filed a case against an Indian in Abu Dhabi and that court of law there convicted the accused person and sentenced him to imprisonment. After undergoing that sentence of imprisonment, if that Indian returned to India, the Indian court can also try him for the same offence if the victim filed this case. And it is for the court to decide whether to convict this person on the same offence or not.
The second question is as follows. If a foreigner comes to India and commits a crime here, then can the Indian police arrest such a foreigner?
Yes, Indian police can arrest such a foreigner and he can be tried in India. However, if he flees India and returns to his country before the Indian police could nab him, then the foreign country's government may initiate criminal proceedings against that person provided the offence that he has committed in India is recognized as an offence in that foreign country's laws. Another option is that foreigner can be extradited to India if there is an extradition treaty between India and that foreign country where that foreign country permits its national to be tried for an offence committed in India. However, if there is no contract or agreement between India and that foreign country, then it is the discretion of that foreign country's government whether to take action against that foreigner for the offence committed in India. For example, High Court of Madras in Maria Stella Rene versus Inspector of Police CBI disallowed release of passport of a French national arrested in India by the Indian police on the ground that if she returned to France, then she would never come back to India for facing the prosecution because as per the extradition treaty between India and France, it barred extradition of its own nationals.
The third question. If the Enforcement Directorate or CBI needs to arrest a person, then are they also required to follow the same procedure of police arrest?
The guidelines followed by Indian police while arresting a person is laid down under the Code of Criminal Procedure, which is timely supervised by the Supreme Court of India. Central Bureau of Investigation (CBI) is governed by the Delhi Special Police Establishment Act, and Enforcement Directorate is following the guidelines envisaged under the Prevention of Money Laundering Act. Both the statutory authorities, Central Bureau of Investigation as well as Enforcement Directorate, have also the powers of arrest. However, while arresting a person, they also need to follow the guidelines which is followed by the police while arresting a person, like informing him the grounds of his arrest at the time of his arrest and taking the arrested person to the nearest magistrate having jurisdiction within 24 hours of his arrest, etc.
The fourth question. If a person has been acquitted by a lower court and the complainant or the state files an appeal against this acquittal before a higher court, then can such a higher court direct the police to arrest this acquitted person even before the case comes up for its hearing?
When a lower court, after hearing the parties, decide that the accused person in that case is innocent of the crime alleged and acquit him of all the charges and release him from custody. In this situation, the state government as well as the complainant can file appeal against this acquittal decision before the Honorable High Court. Now, the Honorable High Court, even before finally disposing of this appeal, can issue a warrant of arrest against the accused person who is released by the lower court after acquitting him. Once the accused person is arrested and is brought before the Honorable High Court, the High Court can either send him to prison or he can be released on bail.
Our final question. If a person commits a crime in India and flees to another country, then can such a person be arrested on foreign soil and brought back to India for trial?
We have heard in news about many businessmen after committing the offense of cheating, fraud, etc., fleeing India to avoid criminal prosecution in India, like Nirav Modi, Vijay Mallya, to name a few. In India, the Ministry of External Affairs names such a criminal as a fugitive criminal and requests the foreign state where they flee to send them back to India to face the criminal proceedings in India. This request is applicable only if there is an extradition treaty between India and that foreign state. For this extradition to happen, the offence that we charge the fugitive criminal need to be an offence recognized in that foreign state also. The foreign state need to be convinced that there is a reasonable case made out against this fugitive criminal. The fugitive criminal need to be prosecuted back in India only for that offence for which extradition is sought and granted, and such fugitive criminal need to have a fair trial back in India, etc. Now, there are conditions where extradition is denied by the foreign state also, where the foreign state feels that the offences charged against this fugitive criminal is trivial in nature, or if the fugitive criminal is undergoing criminal proceeding in that foreign state, or if the foreign state feels that the fugitive criminal is prosecuted on account of his race, caste, sex, religion, place of birth, or the offence is of a political character, etc. In 2018, India has passed Fugitive Economic Offenders Ordinance, which allows initiation of attachment of properties of this fugitive economic offender who flees the country after defaulting multi-crore bank loans and other instances of fraud. Whereas this attachment includes confiscation of properties used as proceeds of crime and also his properties in India as well as abroad.
Thank you for watching. Meet you in the next episode next week with another legal topic. Till then, bye-bye.